Captain, when you think of military justice, right, you think Article 15s, at least in the Army and Air Force, captain's mess in the Navy, office hours in the Marine Corps. I mean, this is the bread and butter of justice for commanders.
That's right. And back in my day, I suppose, which makes me feel old, back in 1820 when I was a trial counsel in the cavalry, Article 15s were a staple of the commander's good order and discipline program. They were used for exactly what the code says they should be used for, which is to effectuate good order and discipline in a rehabilitative way. It was meant to be something that the commander could give to the soldier, inflict some punishment, and put a shot across their bow, get them moving in the right direction. However, recent changes in Army policy have taken that tool away from the commander. And unfortunately, many commanders are not even tracking that this is an issue. And so when they give Article 15s to soldiers, they don't understand the second, third, and fourth order effects on that soldier's career.
Right. I mean, back when I was a trial counsel in the 90s, of all places, seems like, it was like a spanking. You know, when you were a little kid, you got a spanking, got yourself back together, and you drove on. It's not like that.
No, it's not. So the Army at Human Resources Command, which is basically the giant HR division of the Army, this endless bureaucracy, what they end up doing is they have this system called the QMP, which most soldiers have heard of. It's Qualitative Management Program. Essentially, it's a way that the HRC can take this broad, sweeping look at soldiers' files and decide whether they should stay in the Army. Whether or not the commander at the ground level, who should be making those decisions, has made the decision that in fact the soldier should carry on and should be rehabilitated. And what's changed, what's very interesting, is it used to be for any soldier who was E5 and above, when a commander gave them an Article 15, they had a choice on the form. They could choose to put it in the soldier's restricted file or the performance section. Commanders knew if they put it in the performance section that those soldiers were likely to be subject to the QMP program eventually. However, without telling anyone, HRC started scrubbing the restricted areas of the files a couple of years ago. And so now, even if the commander makes the decision that this soldier has something to continue to give to the Army, that this is just that spanking you're talking about from the 90s, HRC is making the decision not based on the person, but based on the file, and pulling it out of the restricted area and then inflicting the QMP program within a matter of months. It's very, very fast.
So the thing that really bothers me is back in the day, you had an Article 15 that you would hold somebody to a standard of beyond a reasonable doubt, right? And so you could win as a lawyer some of these arguments because you had to hold the standard of beyond a reasonable doubt before you could impose any punishment. Today, it's been lowered to the preponderance of the evidence, which it isn't even clear and convincing evidence. It is, I think they did it, right? And that is a really low standard to jeopardize someone's career.
I totally agree. I can't understand the motivation for changing the standard, especially considering the Article 15 still has the ability to be turned down. And so what that essentially means is the soldier can make a decision as to whether they want to accept the commander's judgment at the Article 15 hearing, or they decide, no, I'm going to turn this down and I'm going to invoke my right to be tried by court-martial. And as we both know, at a court-martial, the standard is still what it should be, which is beyond a reasonable doubt, because the government has to be held to account for the evidence that it's bringing about against the soldier in order to jeopardize their career.
Right. You and I both served as trial counsel, and here's what happens in those cases. If you turn something down, the government's not required to just go forward with that Article 15. They'll come back and they say, oh, you turned down the Article 15. They'll scrub the file. They'll find some petty charges that they'll be able to prove beyond a reasonable doubt, and then tag that soldier with a federal conviction. So you always have to be very cautious about turning down an Article 15. In my career, I've advised turn down on 5, and we won all 5 of those cases. But they're very rare.
I completely agree. I do not recommend that any soldier ever turn down on Article 15 unless a good defense counsel has taken a thorough look at the file and has, usually reluctantly, advised that that's the best course of action for this particular case. There is never, as you know in the law, there is never just a end-all solution to every problem, but it is certainly the exception and not the rule when you decide that turning down an Article 15 is actually in the best interest of the service member.
I think it's critically important for service members today, when they're facing an Article 15, to get really good counsel, because you need to be laying your foundation and your response to that Article 15 for the subsequent action, the QMP or a board, or even some other type of action that could follow you later.
Completely agree. That's the first bite at the apple, if you will, for the soldier to present their side of the story, their side of the case, whether that is evidence that this didn't actually happen or evidence in extenuation or mitigation. It's so important that a good lawyer is looking at that packet and making sure that the response is clear, concise when necessary, and provides a good foundation for any follow-on action, including the QMP process. I also think it's important that a good lawyer is able to put into that packet, into that response, enough of the law to ensure that that commander, while they do have their own attorney, that commander still needs to be absolutely aware of the consequences of what he or she is doing to the service member by inflicting this punishment.
Right. And look, we have to litigate 3 or 4 steps down the road. The Article 15, the QMP, the Discharge Review Board, the Army Board of Correction and Military Records, DOD Review Board, and even federal court if it's a violation of the APA, the Administrative Procedures Act. So when we're doing the work at the front end, we always have to keep an eye at what the very end game is.
It's exactly right. It's like building a house. The very first thing you have to do is grade that land and lay the foundation of the house, because if the foundation is not properly built, every subsequent step of the building process is at risk. And what's really important for a service member to look for in experienced defense counsel is to make sure that the person who is laying that foundation at the very outset of this rolling process in the military, that they have a clear understanding of steps 1 through 5, not just step 1, so that you're prepared when you get to step 5. So when you hand the keys to the homeowner, and you got to make sure the roof doesn't fall in.
All right. Well, if you need help with that foundation, we are your warrior advocates at the law office of Will M. Hellickson. You defend the nation. We defend you.